Welcome, everyone. So good morning, good afternoon, and good evening, depending on where in the world you are joining us from. Welcome to this webinar, launching our third update of the Global Citizenship Law Dataset and the first report on the global state of citizenship produced by the Global Citizenship Observatory based at the Robert Schuman Center of the European University Institute in Florence, Italy. My name is Jelena Jankic, and I co-direct the Global Citizenship Observatory together with Martin Fink, Joel Shaw, and Rainer Bauburg. Today's webinar introduces our key findings about the global state of citizenship. We will leave the link to the report in the chat, but you can also access it through our website, globalcit.eu. It's in the slider. Now, today we have with us the authors of the thematic sections of the report. So Martin Fink, who's the chair in citizenship studies at the European University Institute, Ashley Manta-Hollands, a Max Weber Fellow at the European University Institute, Thomas Huddleston from the University of Liège, and Luc van der Baren from the Global Mobility Law University of Copenhagen. We also have a fantastic lineup of commentators on those thematic sections, and it is a pleasure to have with us today Sarah Goodman from UC Irvine, Catherine Harrington from the Global Campaign for Equal Nationality Rights, Paula Alvarez from the International Organization for Migration, the Global Office in Brussels, and Colin Neo, the barrister from Garden Court Chambers. Now, I wanted to start by asking Martin, perhaps, to tell us what the global state of citizenship looks like in 2025. Martin, I hand over to you.
Thank you, Jelena. Hello, everyone. I'm delighted to say a few words about the new data set that we are launching and the report on the regulation of citizenship around the world in 2024. So we're launching version 3 of our data set, which includes information on citizenship laws in 191 countries in the period 2020 to 2024. And this also includes longitudinal data back to 1960 on the acceptance of dual citizenship. And our data covers all the ways in which citizenship can be acquired at birth, after birth, through residence in a country or marriage or another ground such as adoption, special merits, or by investing in a country. And you can also find information on how citizenship can be lost by voluntarily renouncing it or by having your citizenship taken away from you because you have acquired another citizenship or have lived abroad for a long time or are considered a security risk, to name just a few grounds. And you can explore our data in our online searchable database, or you can download the data set from our repository. Now, when mapping the world, or how citizenship is regulated around the world, we see a great variety of ways in how a person can acquire citizenship of a country, as well as the ways in which you can lose it. And of course, this makes it, the first point is that it makes it very challenging to ensure the universal right to a nationality, given that it depends very much on how this is regulated across countries. Most people acquire citizenship on the basis of birth, and people obtain birthright citizenship either by having one or both of the parents are citizens or by being born on the country's territory. Second point, what we see in our data is that these are not mutually exclusive ways to grant birthright citizenship. In fact, most states around the world use both of these birthright principles. And we find that only a minority of countries exclusively apply a descent principle for the acquisition of citizenship at birth. In 27% of countries, a child only acquires the citizenship of that country if one of their parents is a citizen. And this is the case even if the child is born in the territory and would otherwise be stateless. But what if a child is born abroad? This is interesting. In all 191 countries, we see that they apply a descent-based birthright citizenship acquisition to children born abroad to a citizen parent. But whether a citizen can transmit their citizenship to their child abroad depends on additional criteria in just under half of countries. Last point, while some people are struggling to be recognized as citizen, others may have the right to more than one nationality. Having more than one nationality is often due to history marriage and cultural belonging. And over the last decades, we see that the acceptance of dual citizenship has been on the rise. For instance, in 1960, only 6% of the world's countries accepted dual citizenship. And by 2024, this increased to over 50%. Thank you. I leave it here.
Thank you so much, Martin. Now, Ashley, how are questions of gender equality addressed in citizenship laws around the world?
Hi, thanks so much, and hi everyone, and happy to be here and present this section on gender equality. So this is a very interesting and illuminating project to be a part of, and taking only kind of 3 highlights from this section was a challenging task. So the first thing I want to highlight from this section of the report is that we see direct sex discrimination on the decline in the citizenship laws of states. It used to be something that was very common practice, but this type of discrimination has been responsive to global campaigns on gender equality and ending statelessness, as well as international human rights norms. The Convention on the Elimination of All Forms of Discrimination Against Women has an article on gender equality and nationality law. The convention has 189 state parties, making it one of the widest ratified conventions in the world. Of course, there are still holdouts, and our study finds that overall there is discrimination in 50 out of 191 countries, which I'll get to in a minute. But while we're seeing the decline of this kind of direct sex discrimination in citizenship law, if we take a more expansive view of gender identities and sexual orientations, we can see that equal access to citizenship acquisition and transmission still has a long way to go, especially when we look at how discrimination that occurs in family law, equal marriage rights, parental recognition regulations affect how citizenship is transmitted between couples and to children. So moving on from this kind of big picture to our data set, the second point is that from our data, we find that of the countries that do discriminate based on sex in their citizenship law, the most common is in the spousal transfer of citizenship. This can be either where the law explicitly denies women the opportunity to pass their citizenship to their male spouse, or where the process to do so differs between men and women. In terms of birthright transmission by descent, mothers cannot pass citizenship equally to their children in 8% of countries where the child is born in the territory, and 11% where the child is born abroad. Then for birthright transmission by territory, we find that 6% of countries have discriminatory provisions here. And like I mentioned with the marriage acquisition of citizenship, sometimes the discrimination denies the opportunity outright. And in other cases, the procedure for men may be automatic, where for women, transmission is possible, but there are additional hurdles or requirements are less straightforward. Now, these percentages may seem small, but if you look at the share of the population living in these countries, which we have in the report, the number of people affected is actually quite big. I believe that we calculate about 22% of the world population that live under a discriminatory citizenship regime. Now, the last quick point I want to make is that the challenge going forward in collecting data on gender equality and citizenship will be including the legal and policy areas that affect the acquisition of citizenship, as well as identifying requirements that indirectly discriminate against women or minority groups. This could be, for example, differential effects of seemingly neutral naturalization criteria, like economic requirements or language exams, or where parental recognition laws do not allow for same-sex couples to pass citizenship equally to their children. Thank you so much.
Thank you so much, Ashley. And we move on to Thomas. Well, Thomas, immigrant inclusion is always an important topic in public debates. What are your key findings in the report?
Well, so we start off noting how important citizenship is in the lives of immigrants, this citizenship premium that can really reshape their life decisions, their rights, their civic economic integration, their sense of belonging. But we acknowledge the challenge for these ordinary naturalization policies is how do we actually recognize the ties that immigrants have to their new home? Are these requirements based on what all citizens of a country have in common, or are we looking for the perfect citizen and expecting more of immigrants than we do of our own citizens? So when we look globally, there is huge variation. The most inclusive requirements are in the traditional destinations, the Americas, Western Europe, more uneven in Africa and South Asia, most restricted in Central Europe, East Asia, and the Middle East. And our review looks at what requirements are most common globally and least common. So what's universally required is residence. A majority of the foreign-born around the world live in countries where they have to have been there for 5 years or less. The second near universal requirement is good character or a clean criminal record. Language or integration requirements are more contested. Language knowledge is one of the most common requirements for immigrants to prove that they have links to the country. That said, explicitly high language requirements like B1 or B2 on the Common European Framework of Reference for Languages are extremely rare globally. But the fact that most countries require some kind of language knowledge actually belies a much deeper disagreement about the meaningfulness of these types of requirements, because immigrants over time put down many roots in their country in different ways that cannot be measured or demonstrated to authorities. So for example, integration requirements are much less common than language requirements. On this, the world is evenly split. Moreover, the use of specific tests for citizenship are actually one of the least common requirements. And overall, the content of these types of integration requirements can be highly vague and subjective. Another controversial aspect is the requirement that applicants be economically self-sufficient, which can be challenged on democratic and non-discrimination principles. For example, at least 24 countries worldwide explicitly discriminate against applicants based on their health, their disability, or their age. And the least common requirement is the requirement to renounce your foreign nationality. This is really increasingly a relic of another time, and acceptance of multiple nationality removes one of the major obstacles to naturalization. Overall, these legal requirements for ordinary naturalization are one of, if not the strongest factors, shaping ordinary immigrants' opportunities to become citizens. We find this in many international studies linking naturalization with policies, and you can also find that in this report's GLOBALCIT Ordinary Naturalization Index.
Thank you so much, Thomas. And we move to Luke. In the report, you've looked at the loss of citizenship worldwide. So is the status of citizenship a secure thing?
Thank you, Elena. So it seems indeed that citizenship stripping is back on the political agenda. So new citizenship stripping provisions are on the table in Sweden and Germany, and in Hungary, a highly controversial citizenship suspension mechanism has been proposed. And meanwhile, in countries like Nicaragua and Kuwait, we even see that these countries have initiated mass citizenship stripping campaigns. And these developments indeed raise an important question, namely to what extent is citizenship still a secure legal status? And the GLOBALCIT dataset can shed light on this matter by tracking the global prevalence of citizenship revocation provisions and also looking at patterns and trends. So for example, the dataset shows that 132 countries, or 69% of all the countries we cover, you can now lose your citizenship for actions seen as disloyal, such as treason or espionage, or for threats to state security, for example, membership of a terrorist organization. Other security-related loss provisions, such as loss due to joining a foreign military or committing certain serious crimes, are slightly less common, but can still be found in approximately 30 to 40% of all countries worldwide. So what is the problem with these citizenship stripping provisions? Well, the dataset shows that in many of these cases, the provisions are broad and ambiguous, referring to acts as serious crimes against the country or acts that harm the country's prestige. And the broad wordings of these provisions sometimes go far beyond what international standards permit and thereby undermine legal certainty. Procedural safeguards, particularly protection against statelessness or the need for a final court conviction in case of a crime, is often still lacking in many countries. And the dataset finally also shows that a large share of these citizenship stripping provisions are discriminatory in nature, as they only apply to specific groups, particularly citizens by naturalization. This means that citizens by birth have a secure legal status, while those who acquired citizenship later in life do not. And all in all, the GLOBALCIT dataset can be an important tool for monitoring developments regarding citizenship stripping and also help address concerns about states' adherence to international standards.
Thank you so much, Luke, and thank you to all the thematic leads for giving us their key highlights from their respective sections. And now I'd like to invite our commentators to perhaps give us a reflection on these findings. So I'd like to start with Sarah and ask you, how do you see the big picture of citizenship around the world in 2025?
Thank you very much. Thank you for having me. I'm thrilled to be here to discuss this latest version of the data. 191 countries, 2020. Martin mentioned sort of the stats here. What I'm going to do is kind of talk about some of the highlights I see, convergences, divergences, and what we can do with this data. It's such an exciting public good that GlobalCit is providing. And so I hope that people in the audience kind of hear some interesting parts and start picking and playing with the data set. It's really cool. So first with some highlights. These are kind of the 30,000-foot view. So buckle up, we're in the airplane here. We're looking at kind of patterns, trends that stand out. So starting birth and territory, we see the 17% of countries extend citizenship by birth and territory. Okay, so that's interesting on its own. That's 38 countries, mostly in the Americas. And why does this matter, right? We can locate, for instance, contemporary politics within this framework. So the US here is not an outlier. We have context for understanding then Trump's assault on the 14th Amendment that extends birthright citizenship. And I want to highlight here that the overall report has these really neat pull-out boxes, which sort of gives these examples as it goes through these different sections that the authors are talking about. And it makes it a really good, accessible tool for undergraduates if you want to sort of have a gentle introduction to citizenship today for your students. So that was kind of a neat feature that I appreciated in moving through the text. So moving from kind of birth use solely to the other end of the spectrum, we're thinking about kind of every country has descent-based options, but there's 27% that only have descent-based. And so, we can talk about kind of the dynamics of the movers versus those that haven't, and what are the sort of common features that these countries that only have descent-based citizenship have in common, right? The data sets up these sort of interesting comparisons that we can draw between states. So thinking of interesting patterns, I've identified sort of a few patterns of convergence and divergence. And what I want to emphasize here is that what's really cool about this rigorous empirical data set is that it's a matter of perception. So you can move from level of analysis and find convergence at this level, but then we have such refined data that we can move to this level and see where there's meaningful variation across countries. So for instance, you have most countries in the world, 177 in the data set, have residence-based routes to citizenship. Almost all allow also for transfer in marriages. And so that looks like convergence, right? But then we move to sort of a lower level. So moving like from the airplane view to like the canopy view, I guess. We see a divergence, right? So some of the authors already spoke about kind of the sex discrimination or variation in residency durations or other dimensions of security in terms of keeping your citizenship. So we see real variation when we move to that level. You also see divergence in moving to some of the other modes of acquisition that the data set also features. So cultural affinity or public service, refugees, these are sort of all captured within the data set, and it lets us see patterns of divergence even across sort of bordering states. So moving from a regional perspective, we can even get finer grain detail by looking at the country level. 51% of countries accept dual citizenship. So taking a longitudinal view, this looks like real convergence, right? Where we see real change over time, and this data set lets us do that. So 51% have full acceptance of dual citizenship. That leaves about, on the other end, 20% that have no provision. And in between, you have different, allowances by country origin, allowances by destination, right? The mismatching between those dyads. And so across that spectrum, you see a lot of different, practices and different patterns of acceptance. And so, the next step would be for researchers to take this data and look for, reasons why we see acceptance or not, region, regime type, level of economic development, religion, etc. And then last, and this I sort of found most intriguing because it's the one I knew the least about, I guess. Different ways to lose citizenship, right? The increasing adoption of security and disloyalty measures that were just mentioned. So lots of patterns of convergence kind of at one level, and then as we move down, this data allows us to look at things like language or civic integration or disloyalty, different levels in the policy that allows us to identify meaningful differentiation. So my last point is really the so what, right? You invited me to ask about why this matters. So data on its own is neutral, right? We're good social scientists. We know this data is neutral. We don't really know what it means on its own. It's through comparison that we can identify a point of reference or a value, and through the context that we can identify a meaning to it. And so, even looking at the news today, right? Portugal is like, we're gonna raise our residency requirements. So on its own, that's just an observation, right? But what we can see with this data is that this is a departure from the European average, maybe in a political context and sort of similar spirit to the recent rejection of citizenship reform in Italy, right? So we can identify patterns when we start making comparisons. And that's a really valuable use of this sort of tool that GLOBALCIT has given us. So moving then from comparison, we can put that in a context where we move to meaning making. So this data allows us to examine policy settings, patterns of inclusion and exclusion globally, and with respect to dual citizenship over time. And so if we think about explaining continuity or change in citizenship policy, we can then look at correlates across a lot of potential hypotheses like migration flow, migration demand, immigration policy settings, right? If you have very restrictive immigration policies, you may not need to legislate on the back end, so to speak. But certainly then politics or policy diffusion, regime type, economic development, etc., right? So putting it into a context provides a meaning for this data that on its own it does not convey. So gosh, I really encourage people to poke around the website and make meaning out of the data. Last, on a personal note, so hopes to expand this data set even further. We're stymied by the US government and the Department of Government Efficiency in canceling a National Science Foundation grant, who defined global collaborations such as this as no longer aligning with agency mission. So I want to go, being recorded here, I want to be on the record and say that global collaborations and evidence-based science remains a value of American academics and a value of American higher education. And I hope that these collaborations keep moving forward despite current political obstacles. Thank you.
Thank you, Sarah, and we completely agree with you. I'd like to move on and invite Catherine Harrington to comment on how you see our findings on gender equality around the world. Catherine, over to you.
Thank you very much, Helena. I want to also congratulate GLOBALCIT for this and all of the authors to the report for this really fantastic contribution to the field. It certainly is going to be very useful, I'm sure, as our colleagues have said, not only in the classroom and in academic spaces, but of course useful for civil society and our advocacy as well. So thank you very much and for organizing this conversation. Just to kind of ground the conversation in my perspective, so I manage the global campaign for equal nationality rights. I've been fortunate to do that for the past 10 years since the global campaign was launched, and we are extremely fortunate to have amazing coalition members working for gender equal nationality rights in over 20 countries around the world. So my reflections will be kind of with that frame and thinking about what I'm seeing, the amazing work that my coalition members and that feminist organizations and impacted families are doing to realize gender equal nationality rights for all. So, one important point that I know, Ashley, thank you for this wonderful chapter that you raised right up at the top, is that happily gender discriminatory nationality laws are declining. We've seen a steady decline over the past several decades. Of course, this is not happening fast enough for anyone who's still dealing with the inability to equally confer citizenship. This is not a conversation that we should be having anymore, but here we are. With the countries that remain, with any, I think, progress, and I'll get to the really important points about the political dynamics in these countries. Sometimes what you might find is those that are left to have reforms, we have a number of those that are quite challenging for a number of reasons. So you have seen perhaps the pace is not going as quickly as we would like, but there is steady progress, and there has been a steady additional countries that have come in and reformed their nationality laws. So the chapter talks about the fact that, one, that we have a quarter of countries remaining today approximately that have gender discriminatory nationality laws. Primarily, that number includes those that deny equal rights to women to confer on their spouses. But over half of those countries that have gender discriminatory nationality laws today deny women's equal right to pass citizenship to their child. And have other gender discriminatory provisions. The chapter very importantly referenced the kind of real lack of progress in terms of equality when we're thinking about same-sex couples and their ability to equally confer and access nationality. But one point that I wanted to make that we see, and Ashley helpfully mentioned, that in a large number of these gender discriminatory laws can keep state discretion for the ability to confer. So it's like, well, you can apply for citizenship under these circumstances. And in addition to that, just being, patently discriminatory and undermining the very principle of women's equal citizenship or gender equal citizenship and equality within the family. Another very important point that we see very clearly, and anyone that's worked on minority rights will not be surprised about this, where there is state discretion, you see that discretion applied in practice overwhelmingly with discrimination against minority groups. And that those that perhaps are more able to access these rights are those with special access, maybe those that have more resources, that have connections within government. So there's also a link there between, intersecting discriminations and opening up the door to corruption in terms of who can and cannot access rights. In addition to those 3 countries that were referenced that in the past 10 years have reformed their laws to uphold women's equal right to confer citizenship on their children, I also just wanted to draw attention to the fact that we have seen over the past 10 years, 18 countries enacting some reforms, some stepping stone reforms. So in some of those countries, they're partial reforms. So they may have lowered the age that a child of a female citizen can apply for citizenship. In some, they're quite more substantial reforms, such as countries that had already enacted partial reforms, but now removed those last remaining gender discriminatory provisions so that now their law is entirely gender equal. Some of those include Benin, Niger, Lesotho. So we have seen, in particular, a lot of progress in the African region, even though we still have many countries in that region where women can't equally confer on their children. All of those countries, with the exception of Malaysia that I'll get to, is all of those countries that have upheld women's equal right to confer citizenship on their children in the past 10 years have been in the African region. But we are very excited to add Malaysia to the list. We saw, thanks to the tireless and really innovative and powerful advocacy campaign that was led by our amazing coalition member, Family Frontiers, in partnership with a group of fantastic, brave, amazing, impacted mothers. The Constitution of Malaysia was amended by Parliament. It was passed by the lower house last October, the upper house last December, and it has been entered into the official gazette, but there are still some final steps that the government has to take to put that reform into effect. And once that happens, we look forward to celebrating the 4th country since the launch of the global campaign to ensure that women have the equal right to pass citizenship to their children. A couple more points that I just wanted to reflect on, in addition to those countries where the reforms have taken place, we're seeing robust campaigns for reform in many of the remaining countries, promising developments, truthfully, in a number of them. Just this past month, we had in Iraq, our coalition member Women's Leadership Institute hold a high-level convening with government that was convened under the auspices as well of the Office of the Presidency. So this shows the level of engagement that we have in some countries that are looking to address these laws. We've seen regional declarations that have been endorsed in the Arab League and through the African Charter on Human and People's Rights that are setting regional norms for women's equal right to confer citizenship on children. And I think just for a final point that I want to close with, and this was a really important element that was included in that chapter, is the link between discriminatory nationality laws and political structures that prevent the equal access to political representation, to voice, to assembly, etc. We do see a strong link, not that all of the countries that have gender discriminatory laws are not democracies, but there is a very strong link with a lack of women's political representation and addressing gender discriminatory nationality laws. And there's kind of a bi-directional thing here, because it's not only women's lack of political representation that matters, but we also see that where these robust campaigns for reform are calling for women's equal citizenship, it's also shifting national conversations about the very principle of equal citizenship and women's equal status as political bodies, as political citizens, and contributing to the broader conversation about gender equality. So I want to thank the authors again for this very helpful report, and looking forward to the conversation. Thank you.
Thank you so much for your insights, Catherine. I'd like to invite Paula Alvarez to tell us your views on the findings on immigrant inclusion.
Thank you so much. First of all, thanks to the organizers. Congratulations on the report. And thank you so much for inviting IOM to comment on this chapter, which I thought it was extremely interesting. We particularly welcome the emphasis of inclusion in this report as a key dimension of citizenship. And I want to start with a quote from the report that says that becoming a new citizen signals a key moment in the lifelong processes of inclusion and belonging, and I can tell as a dual citizen. The naturalization requirements, yes, vary greatly. And the report also raises this very valid question about the quest for the perfect citizen, which seems to indicate that the states have greater, higher expectations from immigrants than for their own citizens. And at the same time, we note that immigrants have often, are continuously exposed to several barriers in terms of access to services and different outcomes in terms of their own well-being and participation in society. The report also mentions that citizenship laws impact public attitudes and, of course, as I mentioned before, immigrants' socioeconomic opportunities and sense of belonging. I would like to say that a first thought that came to my mind reading this was that I would also say that the other way around is possible, and that public attitudes also influence citizenship laws, and that agency is important. And it made me think about migrants and people with a migration background who also seek to influence citizenship laws. The example it came to my mind was the Italy's National Coordination of New Italian Generations, CONGI. It is an umbrella coordination entity that gathers new generations or associations, mainly led by second-generation youth across Italy that seeks precisely to reivindicate their belonging to a plural society and enhance their representation and participation in society, advocating, for example, for more inclusive citizenship laws and political participation, but also for more inclusive policies in areas like employment, education, health, disability, climate action, international cooperation, and others. A second quote that made me think about a remark was that the report raises precisely this question on how can ordinary naturalization be transformed from a form of exclusion to a catalyst for inclusion. And I think the question is very pertinent, and it made me think about the momentum that in some countries we are seeing about this discourse related to attractiveness and retention of skilled workers and competitiveness, for example, in the context of the European Union. We see a lot of states with pragmatic solutions adapting existing labor migration schemes in a context of demographic decline and also structural skills shortages and so on. So I think the facilitation of more predictable pathways to more secure status for immigrants and their family members, it's not only, it should not only be an economic imperative, but it's a pathway for inclusion and social cohesion. And this made me think about two remarks on the requirements, for example, on residence. Sometimes uninterrupted periods of residence or periods of temporary residence might translate into constraints to consider to be eligible to apply for citizenship. And this is linked to the fact, and the report makes that remark, on acquiring long-term status in the first place, which can be challenging for many. And here I thought about, for example, the proposal of the recast for the long-term residence directive in the European Union to make more efficient and coherent and fair this process. It included some provisions on, for example, allowing for the accumulation of periods of legal residence in different member states, and counting all periods of legal residence, including those granted on temporary grounds. Also increasing the periods of absence from the territory of the EU without losing the status, and some provisions on strengthening long-term residence entitlements for the main applicant and their family members, including to facilitate intra-EU mobility. So as we all know, the negotiations between the Council and the Parliament started during the Spanish presidency. They were continued during the Belgian presidency, and they were not pursued during the Polish presidency, which makes me think that here there's a potential to still advocate and make sure that these more predictable pathways to citizenship, well, to long-term residence, which then links to citizenship, should be pursued. In terms of language, I think this is one of the key issues, and we know that language barriers hinder access to services, employment, education opportunities, and also social participation. It is usually a requirement for acquisition of citizenship. So in this, in this context, I think from IOM, we are at the operational level very concerned about how can we enhance this language acquisition at the earliest possible stage. We have a lot of operations that seek to connect, well, to provide language training at the, even prior to departure, connecting it with post-arrival support measures. But I think overall, one of the key issues to make language requirements more accessible is to think about, for example, the measures that can turn this language acquisition training more affordable, more accessible in terms of location, schedules, etc., more relevant, because sometimes the language training provided by some states, it's at the basic level, when we know that we need more, vocational language learning to be able to access employment and other services and so on. And it should be accompanied by enabling services as well, such as childcare. Thank you.
Thank you. Thank you so much, Paula, for your insights. And finally, Colin, as a practitioner, how do you connect to our overview of citizenship deprivation?
Thank you very much. And let me start as well by thanking the people who contributed to this report, because it's speaking very personally as a practitioner in one particular country. My experience and my knowledge tends to be quite national and quite parochial. So it's fascinating taking a look at how things work elsewhere. Two things, first of all, that sort of jumped out from the report to comment on, and then I'll just close with some brief thoughts. One is that from a UK perspective, the criticism in the report of the vague grounds on which citizenship can be stripped, and the list of criteria there, so service in a foreign army, other non-military service to a foreign country, disloyalty or state security specifically is criticised as being quite vague, or other offences. To a UK practitioner, those look quite specific, quite frankly, because the legal test in the United Kingdom is whether the Home Secretary considers it conducive to the public good, and that's been the test since 2006. So we'd quite welcome some slightly more specific criteria, such as disloyalty or state security or something of that nature. So as bad as things may be, things are capable of getting worse, I suppose, is one way of looking at that. The other thing to quickly comment on, again from a UK perspective, is the the point about discriminatory treatment, and in particular, the discrimination that we see around the world against naturalized citizens, because many citizenship stripping powers are specifically targeted only at naturalized citizens. And that used to be the case in the United Kingdom, but it was changed explicitly on the grounds that it was discriminatory. But of course, it wasn't leveled up, it was leveled down, as they say, so that actually natural-born citizens, birthright citizens, can also be stripped of their citizenship on the grounds of whether it's conducive to the public good, in the opinion of the Home Secretary. And you know, the impact of that, combined with the protection against statelessness, means that dual nationals are discriminated against now instead, because they cannot have their citizenship stripped from them, as the report points out. And also, of course, dual nationals, we often think of as people who move countries, somebody who acquires British citizenship, for example, in my context, through naturalisation. But what we've been finding is that the UK authorities have been very proactive in pursuing denaturalisation, citizenship stripping against those who've inherited a dual citizenship from another country. So the famous, in our country at least, famous Shamima Begum case, she was born in the United Kingdom, and yet she had her citizenship stripped from her, British citizenship stripped from her, because she'd inherited from her parents another nationality, in that case Bangladeshi, because of provisions which allow people to acquire citizenship by descent, something that was dealt with in one of the earlier chapters. So I suppose, again, the thing is, be careful what you wish for, because I think there's a strong argument to be made. I mean, obviously, one argument is to say just don't do it at all, but there's a strong argument to be made that discrimination against naturalized citizens is perhaps less bad than discrimination against dual citizens, where that dual citizenship can actually just be on an inherited basis, which is, of course, how nationality law works. Final comment really is just to think about why this is, and why we seem to be seeing this trend towards increased citizenship stripping powers around the world. And one of them, based on the UK, again, is that it's legitimate security concerns, but pursued in a way that many of us disagree with. So if it's possible, for example, to prevent a person like Shamima Begum, where there might be potential security risks arising in the future should she be admitted to the country, if it's possible to stop her from entering, then security services will often pursue that course, and a very narrow short-term security mindset will consider that to be perfectly acceptable, because it just makes the problem somebody else's problem if there is a problem there. And the other is this kind of conflict between those who seem to see citizenship as a privilege, have a notion that citizenship is precious, but through its fragility, because it's so easy to lose. And then those of us who think that citizenship is more of a right, it's more of a rock, it's something solid, and that's what makes it so precious. And I think it's interesting to think about why it is that we're losing those arguments at the moment. Thank you.
Thank you to you, Colin, and thank you so much to all the commentators on the different thematic sections of the report. Now we have around 17 minutes, so I'd like to open the floor for questions and answers. And I'd like to kindly invite you to raise your virtual hand. I see that Reiner has already done so. Or if you feel more comfortable, please write the question in the chat. So we will be able to take 3 to 4 questions, and depending on the time, we might take 1 or 2 more. So Reiner.
Thank you. Comparing all these different aspects of citizenship on the global scale is really a daunting task. And the report and the 4 reporters have done a fantastic job. But let me suggest that there is maybe something like an underlying pattern that would be useful to consider. And this is that we are witnessing sediments of the history after World War II that then manifest themselves in changes of citizenship law. We have the human rights revolution after World War II, and that clearly feeds into gender equality. And that's an ongoing reform trend. We have the globalization or hyper-globalization after 1990, and that clearly was a main driver of the increasing toleration of dual citizenship. And we have the war on terror after 2001, which clearly was a main motive or main context for the citizenship stripping that Lucas talked about. Now, my question is, in a new context, we may be witnessing something else in the future, which is geopolitical conflicts between states and a breakdown of various aspects of the international order. And the big question is, what will that do in the future to trends of citizenship? Will we see maybe also a reversal of the trend towards global toleration of dual citizenship because of that context?
Thank you so much, Rainer, for this thought-provoking question. Are there any questions at this point? Because I would like to collect, and if anyone would like to ask, I see Christina and Artan, and please let us know who the question is for. And then David Owen. Christina and Artan. Christina, I guess.
Sorry, can you hear me? Super. So thanks a lot. Super great project. I'm happy to join for a year to see what the amazing work you're doing at GlobalCit. And I have a question for Martin and Ashley together, because both your overviews mentioned overall over time still a progressive development, like 50% acceptance of dual citizenship nowadays. Direct sex discrimination has gone down. I just wonder if you put your sort of two insights together, have these more progressive reforms gone hand in hand, or do we more see a patchwork that some countries liberalize on one area but remain conservative or restrictive in another? And then just maybe a question to have more like a catchy takeaway. So what's the hardest country in the year 2025 to become a citizen in, and what's the easiest?
Thank you so much, Christina. I think you've given both Ashley and Martin plenty of food for thought. David.
Thanks. I guess this is probably more to Thomas. In relation to immigrant inclusion, is to the extent to which that also looks at processes by which, if you like, diaspora members can be recruited into the citizenry. So, you know, if we think about inclusion, there's both those who reach a territory, but there's also those in the sort of wider diaspora that the state is trying to recruit to the territory, and the sort of differential, I mean, the extent to which there are differential requirements on them for gaining access to citizenship. Thanks.
Thank you so much, David. Eilert.
Hi, everyone. This is such a wonderful project. Really excited to be here and to hear it. And thanks to the presenters and also the commentators, and of course, Yelena and Martin and Rainer and Joe, anyone who's, you know, responsible for keeping GlobeCit alive and thriving. I have two questions, which in some way might be related, might not be. I think, Martin, in your overview, you mentioned that, I'm not sure if it was you actually, earlier on the discussion, the mentioning that some of the debates that we are very familiar with in the literature about citizenship tests, etc., actually represent a very small number of the world's countries. And I think that in and of itself is very illuminating. So my question, I didn't look at the report yet. My hunch is, my guess, that these would be the, so to speak, more desired destination countries, right? That they are the ones who are putting up these additional barriers, given that they might feel that they are under an over demand and little supply, or they want to more accurately control who comes in. So I'm just wondering if that hunch is correct. And if yes, does that surprise anyone? Because to some extent, I would think that that is just one measure that states would use. And the question, is it legitimate or not? These are other questions that we might ask, but just descriptively, if that's what the data is showing. And the second point which I want to raise or ask is whether some of the more restrictive regimes, and I think we heard this on the gender discrimination front and other fronts in terms of naturalization access, are indeed countries which historically are now what we would refer to as post-colonial countries or global south, right? Countries that at least when they gained independence were really, really worried about who gained citizenship, but from a different angle, not allowing people who might have been the people who have already taken so much from these countries to have necessarily immediate or quick access. So are we seeing, what kind of transformation are we seeing in these kinds of countries? So to some extent, to ask about the context of the countries and how citizenship laws might be related to these very, very different positionings of countries in the world, right? Because to some extent, when we do this large comparison, of course, it gives us the big picture, but I think these nuances might matter. And I think that also connects to Reiner's big question, which is a fascinating one. What happens in a new geopolitical order?
Thank you so much. Now, I'd like to, as we are very restricted with time, well, we have one last question by Luca Barani, and I hope it's a very short one. Luca, and please let us know who your question is for, and then I hand over to the four thematic leads for their short responses.
Yeah, sure. My question was about Italy, which is a quite a battleground state for around citizenship and naturalization. And I was just asking about the symbolic dimension of naturalization, and which complicates things beyond the purely utilitarian and, if you want, rational discussion about that.
Thank you so much. Now I would like to hand back to our thematic leads, perhaps in the reverse order, starting maybe with Luke and asking you for a couple of thoughts on Reiner's question specifically, as geopolitics will also impact the questions of citizenship laws, or a broader reflection on the commentators' feedback.
Yes, thank you very much, Reina, for that question, because I think it's actually a very timely comment. And indeed, if we look at recent changes regarding the provisions for the loss of citizenship or for citizenship stripping, we do see that geopolitical events definitely play a role. You can particularly see this in the Baltic countries, where the provisions have been changed in such a way, or also introducing certain exceptions, for example, related to the situation in Ukraine, that are clearly a response to the conflict. When it comes to citizenship acquisition, it's a little bit harder to find certain examples. One example I can think of is a recent change in Kyrgyzstan, which specifically now allows dual citizenship except for all its neighboring countries, which clearly also has something to do with regional stability. That is still a rather exceptional example, but I can imagine that we would see such exceptions, particularly regarding dual citizenship, more often in the future.
Thank you so much, Luke. Thomas.
So first, what is not covered in looking at immigrant inclusion, we focused here on ordinary naturalization, meaning the rules for ordinary immigrants based on their residence. And the GLOBALCIT database looks more broadly at the nexus between citizenship and migration. So there, of course, you can find the rules for diaspora who might have lost their citizenship and are looking to reacquire it or can demonstrate some form of cultural affinity. But also, GLOBALCIT includes data on the voting rights of external citizens, so those who are abroad. Coming then to this particular focus on ordinary naturalization, I wanted to start with the provocative question from Christina of the hardest and the easiest. Well, I guess the hardest would be the 14 countries worldwide where 9 million foreign-born live, so 3% of all immigrants live in the 14 countries that don't have any ordinary naturalization procedure. Countries like China, Congo, states of the Gulf, and so on. It's great to go through the whole database to really look at the specific provisions in countries. Sometimes they're quite comical, like, can you sing the country's national anthem? But we've got one country I put here. A country requires that you wait 40 years to apply, renounce your previous citizenship, prove your good conduct, your economic self-sufficiency, your knowledge of the country's national language, indigenous language, cultures, habits, and customs. Now, what is the easiest country? Well, there are countries that have very few legal requirements. For example, you can apply after just a few years with little else required, but the report ends by noting that the legal requirements are only really half of the story. 90% of the ordinary naturalization requirements worldwide are discretionary, meaning that applicants who meet all the legal requirements can still be rejected on various grounds. And so they face discretion, but also documentation, bureaucracy with little support or little review. And this might be as important, these procedural elements. And it'd be great if GlobalCit can capture that in the future. So it's hard to say where it's the easiest. But on the particular question about citizenship tests, so indeed, very few countries have these tests. However, half of the foreign-born immigrants in the world live in those very few countries. That's because citizenship tests were part of the traditional destination countries, Australia, Canada, the United Kingdom, and now half of the European countries. So we can ask, is this because these countries have joined the traditional liberal citizenship approach, right? Seeing citizenship as part of the immigration process? Or is the situation in Europe different, right? Europe is also where we see social cultural approaches to citizenship ties more broadly, and where many countries don't provide actually enough language or citizenship courses for people to pass the requirements, right? So it could be used in a more exclusionary manner. But again, this approach is actually very exceptional globally.
Thank you so much, Thomas. Ashley.
Thank you so much. I'll start with Ayelet, your very important question and point about the post-colonial context. I mean, I think that is, I certainly agree with you that the post-colonial context has really mattered in the existence of gender discriminatory regimes. That, alongside with political context, the geopolitical context, social, cultural context, where we see these provisions. And I guess the job now for us and for researchers is now digging into the data, finding those reasons, and doing more kind of qualitative work and pulling that out. And yeah, that is something that I think, yeah, we hope to see from this data project. Christina, for your question, I think certainly what's interesting, I guess, between my section of the report and Martin's is, I mean, dual citizenship and the exceptions of dual citizenship and the push for gender equality. That is historically has been a marriage of. We can see that women's citizenship and gaining equal access has also. That has gone alongside with the acceptance of dual citizenship. Your other point about where we see, like within gender and gender equality and citizenship law, where we see things move liberally in one area and maybe more restrictive in another, certainly. So, for example, where in some countries where we see women's equality, equal access to citizenship, or becoming more equal, we see the rights of same-sex couples becoming less or not moving in that same direction. So I think gender equality can kind of, it can push and pull in some areas and then not so much in others. So thank you so much.
Thank you so much, Ashley. And Martin, over to you.
Yeah, thank you all. Three quick points. So the first one also coming back to Christina's point on the progressive development and the relation between gender equality and dual citizenship. I think in the way that we have seen this development in the law, the causal relation, let's say, is very clear that I think there was a push for gender equality first. And as a result of that, we see that also dual citizenship becomes more accepted, right? Because previously gender equality was restricted in a way in order to restrict the dual citizenship, right? So that a woman who would marry a foreign man would automatically lose her nationality, acquire the citizenship of the husband, and the children would be mono citizens. And as soon as gender equality becomes the norm, then of course the children of mixed citizenship families will be dual citizens, and if we accept the children to be dual citizens, we can no longer it doesn't make sense to ask immigrants to renounce their other citizenship, or immigrants, citizens who go abroad, to lose it, right? So I think that I think causal relation we understand quite well. What it would be interesting is indeed to link that also to the points that Catherine mentioned on political equality, right? So because here, of course, we see also parallel processes, maybe accepting the general principle of gender equality, potentially as a result of international diffusion of norms, right? Such as the Global Campaign for Equal Nationality, which pushes, of course, states to accept this norm, but then how is that reflected in political equality, equal political standing of women, right? And here the causal relation could, of course, go two ways, right? So that I think we haven't looked into much, and that will be really interesting to look at. Rainer, yes, I fully agree that yeah, you have human rights, maybe democratization in general, globalization, securitization, and this is exactly I think the question that Sarah and I were interested in with the NSF project, to look at the relation between citizenship inclusion and political regime development, right? It's not only geopolitics, but also the global backlash and democratic backsliding. And I think the US example, of course, is very telling. One of the first things that Trump did was, of course, do an executive order restricting the application of birthright citizenship. And yeah, we also know other examples, but it's not only about restricting citizenship. Of course, we've also seen in Hungary that sometimes extending citizenship beyond the borders can be part of the consolidation of an democratic backlash, right? So in a way, giving rights to particular groups who you expect will vote for you. And the final point, coming back to Sarah, I think that the so what question is really important for us to keep in mind. So GlobalCit, of course, is a research network. So we are not an advocacy group. And initially we started from, I think, our academic interest, but I think we clearly have this dual purpose in mind when we collect the data. So it is not only to answer ivory tower academic questions, but also to make our data available for policymakers and advocacy coalitions around the world who can use our data to highlight good practices and also to identify laggards, right? And that I think is really something that we keep in mind. And also it's very good to hear the different examples that all of you gave in your comments, and so thanks a lot for those.
Thank you so much, Martin, and thank you to all the speakers, all of the commentators, everyone who has joined us this afternoon or morning in California. Please do share our report among your colleagues in your networks and follow our work on globalcit.eu. Thank you so much. Have a great rest of the day.